Testimonies. Okay, no worries. Just so I can tell the judge what's happening.
Yeah.
No, because they only raised the futility point in their submission, so this must be our reply. Gardner would be main submissions, and Singh would be reply as well. So I think Carrick and Singh are Gardner's. I read that to you just because you'll be reading it. But yeah, that's just the same list as yesterday with ours. And I'm not objecting to anything that's on purpose. Great, thank you. this is agreed. Just in time. Did it change much from what we discussed?
Silence, all stand. This honourable court's now in session. Please be seated.
In the matter of Josephine Davy Green and others, and the Minister for Mining and Industry.
Yes, Mr Jones.
Your Honour, I just had some housekeeping matters to attend to before handing over to Mr Lloyd.
Yes.
Briefly. The first is Your Honour's request for a glossary and a chronology.
Thank you very much.
The parties have agreed those overnight. I'll hand those up, Your Honour.
I'm grateful to both counsel. Well, and presumably all counsel.
Yes.
I guess you probably delegated.
Mr Lloyd and I definitely
Thank
did
you.
not take the lead on preparing that.
Well, I'm grateful. Thank you.
Your Honour, the next point is we've had printed some of the authorities that are referred to in our submissions. We've tried only to print the ones that I elliptically referred to yesterday. If I could hand those up.
Thank you very much for that.
And once Your Honour has it, I'll just tell Your Honour where they're referred to in our submissions and which paragraph numbers we rely on.
All right, thank you.
The first one Your Honour should have behind tab 2, the first tab is Carrick. That's referred to at paragraph 76 of our reply submissions, and the relevant paragraphs of the decision itself are 26 and 27. And that's a case about futility.
Yes.
The next case is Gardiner.
Mm-hmm.
That's referred to at paragraph 100 and footnote 87 of our written submissions in chief. The relevant paragraph of the case on which we rely is paragraph 30. That is a case about fettering of discretion.
Yes.
The next case is Singh. This is referred to at paragraph 27 of our reply submissions. The relevant passages are paragraphs 46 to 47 of the decision. That decision is authority for the proposition that when reasons have been given for a decision, one looks at those reasons to assess legal unreasonableness.
Yes.
And the final case is not one that's referred to in the submissions or was in the electronic court books that were filed, WCJS. This case makes good the proposition I put to Your Honour yesterday that when one is concerned with a mandatory relevant consideration, which is what I said assessment report 86 was, a factual error in relation to such a mandatory relevant consideration has particular importance in assessing jurisdictional error, and the relevant paragraphs of that are 107 and 108.
Factual error is of particular importance in assessing jurisdictional error. Yes? Thank you.
And then
That's very handy.
Then I have 3 further documents to tender.
Mm-hmm.
Perhaps if I hand them all up at once, that will save
Yes.
the courts running back and forth.
So the first one, how do I describe it?
The first is a letter from the EPA to the department.
The department, and I put a date on it, do I? You mean an email?
It's an email attaching a letter.
Oh, I see.
Sorry.
Date 3rd of March 2022 will be exhibit P20.
Your Honour, the...
So do you want, where did it come from? Court book 6, volume 6, tab 113, because it's best to keep track of them that way, I
Yes,
think.
I'm grateful. Your Honour.
Thank you. Next one?
The next document, Your Honour, I handed up yesterday when I had trouble with the Excel spreadsheet, a hard copy of the security calculations,
Yes?
but I neglected to have those marked as an exhibit.
All right.
So this is intended to be something that can be marked as an exhibit. It is a hard copy of what Your Honour marked as P15.
Okay. So it's P15. I'll just,
I'm grateful. And then
okay, so, let's write that on the top here. Yeah,
And then the final one is the blank security calculation tool.
oh, sorry, this is P15.
Oh, I'm sorry, Your Honour.
No, that's all
Probably
right.
put it in the wrong order. Yeah, the one that says insert name here is obviously the blank one.
Okay, so exhibit P21 is blank security calculation tool, is that right?
That's right, Your Honour, and I just wanted Your Honour to have in evidence what the tool itself is before it gets
Yes.
filled in.
Yes. Thank you.
Perhaps for good order, Your Honour, my junior rightly suggests I should tender the native version, the Excel spreadsheet of the blank tool that I just handed to Your Honour.
I don't understand what that means.
Well, yeah, so there's an Excel spreadsheet that one can play around with, if you like, and see how all the cells interact that one might not entirely get from looking at the hard copy. I'm not going to take Your Honour to that. I just would like to have it in evidence.
So the blank security calculation tool plus, what is that? A
native Excel file.
native Excel file, all right?
Tab.
Will
Tab.
both be exhibit P21.
I'm grateful, Your Honour.
Thank you.
Thanks.
That's it? All right. Lovely, thank you. Yes, Mr. Lloyd.
Your Honour, if I might start first of all with our evidence. First of all, our affidavit evidence. There's 4 affidavits of Mr. Padovan, which we read.
Yes, is there any objection to those? I gathered there was from some of the,
There's some objections that have been agreed by my learned friend not pressing things. There's a list of those, but I withdraw all other objections that are not agreed.
all right, so the
If Your
4
Honour-
affidavits are, so,
So perhaps I could hand up, if it's convenient to Your Honour, I can hand up a list of the paragraphs which are not read.
lovely, that would help, thank you.
In some senses, it's just a couple of words that are not read.
Yes,
But those
thank you.
affidavits, I think, are all in a bundle that you were given yesterday, the key documents bundle.
Yes, I think that's right. So there are 5 affidavits, you're reading them all, and
Yes,
these are
there's-
the only, no?
There's 4 affidavits.
It's just that you've got here 5th affidavit.
Yes, but we don't read the second affidavit.
Good, okay. So 1st, 3rd, 4th and 5th affidavits. We better give them different numbers, right? So first is D1, second is D2, no, sorry, third is D2, fourth is D3, and the 5th is D4. With those deletions,
Exactly.
we'll have those exhibit numbers. Thank you.
Thank you. And if I just introduce Your Honour to what, I mean, I'll be taking on specifically to a couple of bits of them, but broadly speaking, the first affidavit,
So, I'm sorry, before we do, could you hand me those affidavits, please? They're in that folder. Thank you very much. Lovely. Yes, okay, we've got them.
Your Honour will see that Mr. Padovan is a Senior Executive Director in the Mines branch
Yes.
of the department. He's not the person who made the decision, who of course was the Minister of the decisions, as my friends characterise it. The decision maker was the minister. However, he, as will be seen from the affidavits, he played a sort of a central role in preparing the material for the minister. He's been in the department for 6 years, in that post for 6 years. The nature of his role is explained in paragraph 4. It gives some background to the MRM mine in paragraph 6. In paragraphs 14 to 19, he gives evidence as to all the documents that were before the minister.
Now, those documents, because the material is so voluminous, and I do not want to read documents that are not relevant to an issue in the proceeding, my preference really in this sort of matter is to just accept as exhibits the substance of the affidavit without the exhibits, unless all of those exhibits are key documents that you want me to read. And if they aren't, then to have as separate exhibits just those bits that, as we did yesterday.
Certainly. So what I'm about to do, after I've gone through the affidavits, is give Your Honour 2 folders which have all of the tabs from the big court book that we refer to.
Good.
Other than the tabs that are already exhibits or the tabs that are already in that document that Your Honour has.
So you are tendering, say the first affidavit of Mr. Padovan, you want it to be Exhibit D1, not just the substance of the affidavit, but all of the exhibits to it?
No. So
Okay.
we're tendering that affidavit as just the substance of the affidavit.
Yes.
And then separately in this folder, we will
Okay.
provide any other separate exhibits.
And you want that folder exhibited as one exhibit or each one
I
separately?
think it would be easier to be one exhibit. They have the same tab numbers as the court book, so that
Right.
way we can just refer to the tab
All right.
numbers. It also has this advantage that what we've included in there is some documents that are referred to in our written submissions
Good.
that I'm not proposing to go to orally, but we're not abandoning them, so at
Yes.
least Your Honour will have it in evidence if
Yes, thank
you read
you.
the footnote and you think, I wonder what
Oh,
that says.
where is that? There it is, yes. All right, thank you very much. That makes things workable.
Thank you, Your Honour. Then, in paragraph 21 of the first affidavit, D1, there is reference to the documents containing the challenged decisions.
Yes,
Then at paragraph 28, there's some information as to how the security recommendation was made.
yes,
By way of introduction, that's all I want to say about that affidavit. In relation to the third affidavit, which is D2, the purpose of that is noted in paragraph 4 of the affidavit. It identifies the department's processes for briefing the minister in paragraphs 5 to 7. It provides greater detail about what was and was not put before the minister in paragraphs 10 and 11. And then the balance of the affidavit relates to requests of information sought by the present plaintiffs and really is probably irrelevant. We won't take the court to any of that. The fourth affidavit, which is Exhibit D3, the purpose of that is explained in paragraph 3. It explains how the department administers the scheme. While the documents speak for themselves, this evidence provides background on the framework that creates them in a particular form and thus can assist, we say, in construing them. It also refers in paragraph 22 to 2 more recent security decisions having been made. So there's a 2021 and a 2022 decision. They're referred to in paragraph 22. And we will, including in this bundle, I understand it, will be 2 variations of authorisations that were made pertaining to those 21. So they changed the security amounts and they're in the new authorisations. Its relevance is only to what we say is the futility argument,
yes.
which is to say that my friends are not challenging the operative decision and that affects whether relief should be granted in respect of that. Now, if I just foreshadow now, we're not saying if they are in some respects successful, they might get no relief. But if, for example, Your Honour thought that there was unreasonableness in making the decision in some regard, Your Honour might make a declaration to that effect, that that was unreasonable, without setting aside what is already an inoperative decision.
Yes.
And then obviously my client will take
But you're
that
not
on
saying
board.
that in those circumstances, if the decision is that essentially the plaintiffs are right and the mechanism that's being adopted for the fixing of the security is unlawful, that there wouldn't be a declaration to that effect? You are saying there wouldn't be a declaration to that effect?
I'm certainly saying you wouldn't quash it because
No, I understand that. I understand that, but there's two different things. Quashing the decision, which you say would be futile because no longer an operative decision, and making a declaration to the effect that the mechanism is, well, it would really be to the effect that that was an unlawful decision, and they're just for the purpose of saying, well, that's not the way you do it.
certainly we accept that Your Honour could say that. Whether you go so far as to say it was, you could say that the making of the decision without having regard to X was unreasonable in the circumstances of this case.
Yes.
That certainly we accept could be made. That would give guidance to my client and could be perhaps justified for future purposes.
Yes.
The only issue about granting, making any declaration that the decision was invalid at the time, and I'll come to this
Without quashing it is a bit weird.
without quashing. First of all, if you can't quash it, you shouldn't be able to make a declaration that has the same effect. But also, there was an issue which we haven't particularly re-agitated, but at an earlier stage of discussions with my friends, we said that if their argument is right and the authorisation was invalid, then the mining activities were not authorised. And if the mining activities were not authorised, MRM has then committed crimes, and they should be joined.
Right.
And the plaintiffs has, indicated they don't want to join them.
Well, hang on. You've got a point there. I mean, that's a very valid point. Should they be joined?
Well,
This is really affecting their...
there is correspondence to that effect. We said they should be joined. They said they didn't think they should be joined. We said we would mention this in court and let the chips lie where they fall.
Well, hang on.
If there's only a declaration that says there was unreasonableness, that doesn't necessarily then, a declaration, first of all, it has no binding effect.
No.
So it wouldn't necessarily result in MRM committing a crime.
No, but... No.
Your Honour, could I just complete the chronology of what my learned friend said about them raising the issue is quite right. And as a result, my solicitors wrote to MRM to ensure they were on notice of the proceeding and to confirm whether they wished to be joined, and we never got a response. Now we have and I understand representatives of Glencore were in fact in court yesterday. So we have an affidavit from those instructing me about the steps that were taken to send that letter to MRM. So it's certainly not the case that they're not on notice or didn't have the opportunity to seek that.
Well, perhaps we could deal with that this way, and that is I don't want to hold up these proceedings. And if they're on notice and they had someone in court, yes, that's all very well, but perhaps we'll proceed today with the submissions from the Minister, and then perhaps I can leave it to Council to make a further overture to MRM saying that if they wish to be joined, then they should make application to do so, and there will be a further hearing date at which they can say whatever they want to say about the issues. No?
I think we're content with that, although I accept entirely what my friend says. We accept that MRM are on notice of the case, and we
Yes.
accept that they haven't sought to be joined.
Right.
But that's a slightly separate question as to whether they're a necessary party.
Yes.
They might, I don't act for them, I don't know what they're saying. They might think they are a necessary party, and the fact that the EDO haven't joined them somehow gives them protection. I don't know what's informing their thinking, but we certainly did think they were a necessary party, but the plaintiff says they're not. And so that's then a matter whether Your Honour is satisfied.
You say they're a necessary party because at least on one view of the matter, the relief that's being sought by the plaintiff would have the implication of a declaration to the effect that MRM have committed a crime.
Certainly, the relief they seek is that the authorisations are invalid. That's MRM's authorisation.
Yes.
And that results in MRM committing crimes, or at least potentially, arguably. I mean, I'll come to the legislation. However, on our view, if none of that relief is available anyway because they're not the operative decisions, Your Honour wouldn't give that relief. And then a declaration, which is not binding, which is only to the effect of there was some unreasonableness, but doesn't purport to set aside or declare invalid the decision, arguably then they're not a necessary party. So there is a way through.
All right. So if there is a way through where they're not a necessary party, then it still might be desirable to hear submissions from the minister today and yet send out through council notice to MRM that if they wish to make submissions in relation to these matters, then they've got like a week to make written submissions or make application through my associate for a hearing date. Does that work?
We're content with that, Your Honour.
All right.
And then the fifth affidavit, I'll be coming to the fifth affidavit, so it deals with, mostly anyway, with the issue of 10-year post-monitoring issue and the recommendation 12 issue, but I will come to that, so I won't foreshadow that. So that's that. Now, if I can hand up these two volumes. One at a time.
Right. Now, how am I going to describe them, Mr. Lloyd? Just put them
This
down
is
there. Two
the
volumes of two volumes of
two volumes of documents relied upon by the minister.
right. Two volumes of documents relied on by the minister will be Exhibit D5.
Now, can I immediately make two observations? One is, if Your Honour looks, I understand under the first volume there's an index.
Right, let me have a look at that. Swap. Thank you. Yes.
And so I just want to say that, I mean, this was done last night and a couple of changes this morning. On the second page, 5 from the bottom is the MRM security calculation.
Yes?
Now, we included that in that folder because yesterday it wasn't marked, but Your Honour has now marked it this morning. So
That's a
the
repeat.
fifth column, you might want to note that is P15.
Okay, I'll do that right now. 1, 2, 3, 4, 5. P15. Yes, I have it.
And then in the bottom, the penultimate entry on the third page, which is NAC 13,
Yes?
that is also the document that my friend handed up this morning, which is now P20.
P20. Okay, I have that. Thank you.
So that's that. And then I said wrongly that the two new authorisations were in that bundle, but apparently they weren't, so I can hand those out.
So Exhibit D6 equals 2 new authorisations. Is that right?
Yes, and I can indicate that
So that's 2021, 2022. So I'll just put that in brackets.
they're only tended really to prove the fact of them. rather
Yes,
than-
all right. No, that just... So the two new authorisations for 2021 and 2022 will be Exhibit D6.
Okay, that's our evidence. It is possible, because we were doing things simultaneously last night, that I will have added something to my speaking notes which isn't in that bundle, in which case my junior and instructing solicitor has apparently all of the other tabs over there, and we'll provide that to the court if that happens.
All right, thank you.
Okay, so in paragraph 4 of our written submissions, we divide the plaintiff's grounds into 3 categories. My friend has divided them into, 4 categories. My friend has divided them into 3 categories, but then category 2 has an A and B category. So Your Honour will see that we're more or less
I can follow that, yes.
Now, either expressly or by implication, each ground asserts some form of departure from the Mining Management Act. I'll address those grounds in turn, but first of all, I want to spend some time on the MMA, the Act, and then on to the general facts, all by way of introduction, so that when I get to the grounds, I've laid out the background. So to that extent, do we have volume 9? We'll just give it this. Your Honour has a copy of the Act, is that right?
I do.
What version of the Act does Your Honour have?
As in force at 28th of June 2020.
Okay. So what I might do
It's a reprint.
is hand up.
I'm hoping it's up to date.
I think it is up to date, but that makes it wrong.
Okay, you're looking at an older version of the Act. All right,
So
thank you.
you keep that version, because I'll need to take you to something just to show that that's the wrong version.
Thank you. Thank you.
So in the version that Your Honour already had, if Your Honour can turn to section 105.
Yes.
So Your Honour will see this section applies if 3 conditions apply. And then it says the Act as in force immediately before the commencement, that is of this 2019 transitional provisions, continues to apply to the determination of the application for the authorisation or approval. Now we say, and I don't think this is controversial, that those 3 conditions in 1A, B and C have all been met in this case.
Yes.
So the first condition is the application for an approval of an MMP is made before the commencement, and that happened. It commenced on the 28th of June, but the application was made in January 2020. The second condition is that the EPA's Environmental Report 86 was completed in 2018, and therefore...
Before the commencement of the...
Therefore, before the commencement. And so, anyway, so as a result of that, it's this earlier version of the Act that is the relevant version. But
Yes.
I just thought I'm not sure, I don't want to trouble Your Honour, I'm not suggesting that to the extent that Your Honour looked at the other version yesterday, there's no big changes, I think, that are significant, but there are some minor changes.
And in fact, the part that I think that you referred to in your written submissions, which I've now had an opportunity to read, about the older Act applying, well, Mr Jones was actually using the older section in his submissions.
Yes.
So there's no real controversy between you about that, is there?
I don't think so, no.
No.
So I'll go to that older version. I need more space. So that is in tab 28 of volume 9. Now, if one starts at page 817, so I'll use the, hope what I've given up has the court book page numbers on because I've marked, but anyway, I can refer to sections anyway. But
Yes, sections are handy.
the I just note in passing the long title of the Act. It's about to provide for the authorisation of mining activities and protection of the environment on mining sites. And then one gets a similar flavour from section 3, the objects. And then we note paragraph A, reference to the best practice in the mining industry. Paragraph E, which is relevant to the security.
Minimise the liability of the territory.
Exactly. Then there's a definition section, and I just note in passing, there's a definition of the word authorisation that comes out of Part 4, Division 2. I'll go to that in due course. There's a definition of the word mining activity. And that's kind of an elaborate definition, but it covers most things you think occur in a mine site. There's a definition of operator, which picks up the meaning from section 9.1. Definition of security, which picks up the meaning from 43.1. Section 5.1 makes it clear that the Act applies in relation to all mining sites and mining activities in the territory. Then in 9.1, the operator for a mining site is responsible for the control and management of the site and the mining activities carried out on the site. So that's what the operator does. We'll go down a couple of pages to part 3, the heading of the environment. Environmental obligations. I won't deal with that in any detail, but I just note existence. And then in part 3, division 3, which is down, there's environmental offences. Those offences relate to breaches of the environmental obligations referred to in Division 1. So all of that is the context in which Part 4 arises, the regulation of mining activities. And Part 4 starts at section 34.
Section 44.
34.
34, righto. Got it.
Section 34 requires that the Minister is performing a function in Part 4 to have regard to the mining interest held by the mining site. So that's always relevant. So if you've got a mining lease or an exploration licence or whatever, that's to inform decision making. So that's, I'm not saying anything turns on it, but just to give the operation of the scheme. In granting an authorisation under 34.2, under the MMA, the Minister must ensure that conditions in the authorisation are not inconsistent with any conditions in a mining interest, and there's no suggestion of that here. Going to part 2 of Division 4, starts at section 35.
Sorry, Division 2 of Part 4, yes.
Sorry, Division 2 of part 4.
Authorisation.
To carry out mining activities. So 35.1 has the effect that a mining activity may not be carried out on a mining site unless the minister has granted the operator an authorisation to do so. So the authorisation, the main function of that is that it gives you permission to carry out mining activities. At least that's so when one looks at subsection 2, where the activity involves a so-called substantial disturbance of the mining site. And then subsection 3 identifies the kind of things that might constitute a substantial disturbance. And although that language is a bit different to section 43A, we would say at least 43A at least embraces all things that are substantial disturbances. But I'll come to 43A. 35 subsection 4 is an offence to do a mining activity for which an authorisation is required but not granted. So if you need an authorisation and it's not, we would say, validly granted, then it's an offence. And that's part of the reason why we say that the applicants, the relief the plaintiff seeks is one which puts MRM at risk.
Yes.
Section 36, an operator who requires an authorisation must apply in writing, 36.1. An application must be accompanied by a mine management plan, 36.2. And then from 36.4, we say it's apparent that the mine management plan, the approval of the mine management plan and the approval of the authorisation kind of go together.
Yes.
Sort of
So you
bind-
can't do one. You do both or neither. Yeah.
Exactly. In subsection 5 of section 36 identifies a sort of a state of satisfaction that must be reached. So it's that
The minister must be satisfied. Yeah.
so it's not an objective fact; it's a state of satisfaction issue. Then section 36.6, the minister is obliged to give reasons, but only if an application is refused. Now, I
Right.
make this point because there's no obligation to give reasons in this case because the application wasn't refused.
No, but reasons were given, so.
Well, but it's not that straightforward because there is a document called Statement of Reasons, and I will come to that in due course. But if there's no obligation to give a statement of reasons in any particular form, you can't infer that it's meant to be a comprehensive statement of reasons. It might say that the things in the statement of reasons are amongst the reasons, but they don't have to be comprehensive. Now,
So you say obligation to give reasons only arises on refusal.
indeed,
Therefore, no obligation here. And you say the implication for the document headed reasons is, so therefore and I'll put them in bracket thingies, inverted commas, reasons may not be comprehensive, you say.
yes, you can't infer that the statement of reasons is a comprehensive statement of reasons.
Why wouldn't you though?
Well, because where there's an obligation to give a statement of reasons, that obligation is usually put in form that you must state the decision and the reasons for the decision and the facts upon which it's made. And then from that obligation, knowing that that's what the statement of reasons has done, then you will assume that it's comprehensive.
But if somebody says, these are my reasons, wouldn't you naturally infer that those are their reasons?
I'll refer Your Honour to a case where the full court of the Federal Court declined to draw any such inference.
All right.
In a case where somebody had a statement of reasons and they filled in something that purported to be a reason, and not only would the court not infer that it was their reasons, but the court declined to draw a Jones and Dunkell inference that unless they put on further evidence, there were other reasons. So, and
Okay, that's interesting.
I'll give Your Honour a reference to that in due course. But if I can say something else, I mean, in a sense, in the current case, it becomes more apt or more relevant when it comes to the security decision, what's characterised by our friends as the security decision. There's no obligation to give reasons why the security decision was made in any particular form. And unambiguously, whatever one gets from the document called Statement of Reasons, and there are some issues with that document, but whatever one gets from it, it isn't purporting to give reasons for on a line-by-line basis of the security decision. So there's just no basis to infer that the Minister was giving reasons for why she decided, why she accepted a number with a 10-year post-closure monitoring. She just,
Well,
the
I
reasons
don't
don't address that.
Well, I don't think that cuts across what Mr Jones was saying, because he wasn't complaining that she hadn't given reasons, or he wasn't pointing to that document as purporting to give reasons. What he was saying is that there's clear documentary evidence that the cost of the clean-up, or whatever you want to call it, of the closure will include monitoring for 100 years, and yet she has chosen the form 10 years, which is unreasonable on the face of it. It's not a question, because I might be wrong about this, but I did not construe Mr Jones's submissions to be about reasons or whether that document, the calculation tool, constituted reasons. It was the contrast between documents from the mine and I think from the Minister's department, all in the possession of the Minister, which showed a clear indication from the operator that the cost of the closure would include monitoring for over 100 years, which wasn't then reflected in the calculation, because the calculation was arbitrarily limited to 10 years. That's what and that was prima facie unreasonable. I mean, on the face of it, rather, unreasonable.
I understand all of that. Maybe if I'm going to come to this all later. At the moment, I'm just doing that. But if I just foreshadow what my point is, my friend did take you today, or mention a case called Singh today.
Yes.
And Singh is a case in the migration context where there is an obligation to give a statement of reasons, and the court says you can decide whether there's an intelligible justification or not from what's in the statement of reasons.
Yes.
And that's, of course, in a context where there was a duty to give those reasons comprehensively. So
I see.
that case has to be understood in that particular box.
All right.
Normally, in a case like this where one does unreasonableness, one has to show on all of the material before the Minister there was no rational basis for it.
Yes.
And that basis, that material includes stuff that was actually before the Minister and material constructively before the Minister. We accept that it's open to them to say that on all of the material that was actually or constructively before the Minister, it's not reasonable. But then that involves them putting on all of the evidence that was actively or constructively before the Minister, and then saying that you can't have an intelligible justification from it.
Yes, I understand. And I won't interrupt again. I was sorry. For your overview, because it's distracting.
No, I'm more than happy for Your Honour to ask any questions.
Yes, but I'll wait till you finished your overview.
Thank you, Your Honour. So that brings me to section 37, I think. Section 37 concerns the duration and conditions of an authorisation. Subsection 1 provides that an authorisation is granted for a period and is subject to conditions specified. That is, the mining activities, the subject of the authorisation instrument may be carried out only within a period specified. We're not saying that is this case,
No.
but it could be done that way. Of more importance, the authorisation for mining activities may impose conditions on the carrying out of activities, such that authorisation to carry out those activities is not given unless and until the conditions are met.
Where
We
does
say
it-
that 37.2 includes 2 mandatory conditions, and then under 37.2C, there's then a very general power for the minister to impose other conditions. And Your Honour will have seen in the authorisation in this case, there are, I think, in excess of 100 conditions which have been imposed. The mandatory conditions...
Which is, oh, sorry, I'm interrupting again. Carry on. I was going to say, one of which you say is that they have to put in a new unplanned closure plan every year, and that the authorisation is subject to compliance with all the conditions, including that one.
Indeed.
Right, I get it.
So we say, I don't think there's a challenge to the validity of that condition. So that is just a condition that can be done. Now, there is a dispute as to whether those conditions constrain what activities can be undertaken. As I understand my friend's case, they say that everything in the mining plan is authorised and that the limitations on the conditions don't limit what mining activities can be undertaken, and therefore, they say, the calculation doesn't cover the whole life of the mine activities which are in the mining plan. They only cover this subset of key activities.
And you would be hard put to say that the authorisation doesn't cover all of those activities, given all of the indications that, you know, this authorises this and another document saying this authorises that. But as I understand it, you make a distinction between what's been authorised and what is to be carried out within the meaning of section 43 capital A. And that is that under the authorisation, or these authorised activities can only be carried out if they comply with the conditions of the authorisation, which includes putting in a new unplanned closure plan every 12 months. Have I got that wrong? With the net effect of which is that the only thing to be carried out and each year are the activities that are really the subject of that year's unplanned closure plan.
I think I mostly embrace that. I would say, however, that we don't say that everything mentioned in the mine management plan is an authorised activity. It's, at least let me put it this way, it's not an activity that can be carried out under the authorisation, because the authorisation doesn't allow you to carry out every activity that's mentioned in the mine management plan, only the ones which are planned to be undertaken in 2020, which are in a list. My friend took you on to the list of the ones that are planned in 2020 and the ones that are planned later. So all the ones that are planned in 2020, they are what's authorised, and that what has been the subject of the security calculation. And I'll come to this.
But you don't need to say that they're the only ones that are authorised. You mean you could live with, I would have thought, Mr Jones's characterisation of having them all authorised, but the only ones that are going to be carried out within the meaning of section 43 capital A are the ones that are that have been covered, if you like, by the current unplanned closure plan.
Well, that's, I mean, I accept that it can be characterised in slightly different ways. Maybe I put too much emphasis on to be carried out under the authorisation, but we say the net result of it is, when one looks at condition 12, you can only carry out things, like it would be a breach of the condition 12 if you carry out something that isn't in the security calculation. And so to that extent, it can't be carried out under the authorisation.
Yes.
So whether it is in some senses covered by the authorisation, it is not something that can be lawfully carried out, because it would be a breach of a condition to carry it out. And in that sense, for the purposes of at least the process of 43A, it doesn't, the things that can't be carried out don't have to be factored into the security yet. And that's why when you've carried out those things, or you want to, maybe you don't have to have even finished carrying out those things, but if you want to do some new thing which you didn't plan to do in 2020, then in 2021 you come along in your 2021 UCP and say, we now plan to dig a bit further this way or whatever. There's a bit more disturbance. Then my people add up the extra costs associated with that extra bit of disturbance and they adjust the security. And then because it's covered by the security, it is then something that can be carried out under the authorisation.
And that's predicated on the fact, on the assumption that the security that's been calculated actually does and is intended to cover the the cost of making good, if you like, the disturbance from the activities in that year.
Yes, I mean,
And that might not be the case, according to the plaintiffs.
maybe I should make this clear now, although again I will get to it. But we're not saying that the authorisation is to do things during the calendar year 2020. That was one of the things put against it.
Yes, no.
It's what are you planning to do in 2020? We will authorise the things you're planning to do in 2020. It might take you longer. COVID might come in. You might drab into it, but
You can do that, no more. You don't have to do that, yes.
you can't do anything beyond what you've currently planned, because that's what we've calculated the security by reference to, and you're not allowed to do things for stuff that isn't covered by the security.
Yes, I understand the argument.
Thank you, Anna. So that's 37, I think I've covered. 38 is concerned with the variation or revocation of an authorisation. The Minister may, of her or his own initiative, vary or revoke an authorisation. Then Part 4, Division 3 is headed Mining Management Plans. The expression is defined or explained in subsection 1. The mandatory parts of the plan, the mining management plan, are specified in 40 subsection 2. We draw attention to several paragraphs. First to C, the plan identifies the mining activities that ultimately require authorisation. So that's not necessarily that they're being necessarily authorised now, but they are things that require authorisation. Obviously, mining technologies can change, and there might be changes in plans, etc., etc. Then in F, the plans of proposed and current mine workings and infrastructure. And we say that that is at least capable of including, proposed at a particular point in time. Mm-hmm. And then more importantly, G, that identifies there must be a plan and costing of closure activities. We say the operator is under a duty to ensure that the environmental impact of mining activities is limited to what is necessary for the establishment, operation and closure of the mine. That's section 16, subsection 1, which my friend took the court to yesterday. So that's what the operator is under a duty to do. So in context, section 42G requires an operator to have a plan to close the mining site. Now that it might be closed, it has to have a plan that meets that idea. And we say the unplanned closure plan, in this case, meets that requirement. It is a plan having regard to the current and expected and sort of having regard to the mining activities that have taken place and the mining activities that are authorised to take place without needing any further authorisation. This is the plan to how to fix the mining site and rehabilitate it in those circumstances. That is what is required, and that we say is what's done. Now, we accept that there may be instances where you have a very large mine and mining is expected to take place over decades, that you will want to have, not only a plan to fix the mining site as it is at a particular point in time, but also you want to work towards what you're going to do at the end of the day if it does go to full fruition. We're not saying that the MMP can't include that or shouldn't include that. We're just saying that a plan which looks at what needs to be done in relation to that which is authorised or able to be carried, maybe I shouldn't use that expression.
Able to be carried out.
Able to be carried out under the authorisation is one, on that basis, if the mine stops, whether it stops because the price has gone down or there's a flood or, technology has meant that lead isn't required anymore or whatever the reason that it stops, it might stop earlier, but on that basis, the plan is an actual plan which says what needs to be done to rehabilitate the mining site, at that time. And
It's sufficient for there to be a plan to rehabilitate the mining site after the activities currently to be carried out.
Yes,
Is that it?
that's it.
Got it.
Now my friends that said there was some kind of inference to be drawn from the order of the paragraphs in section 2, that because the closure plans is at the bottom or near the bottom of that list, but therefore that means it must be a life of mine, only a life of mine. We say that is a bizarre and extreme inference, not supported by the text, nor supported by the structure. Our construction, or that at least allows a plan to be a plan that takes into account all of the mining activities that can be carried out under the current authorisation, is one that meets the purposes of the Act, because they're the disturbances that are foreseeable on the basis of the current authorisation, and there's no reason to have it must be the life of mine and nothing short. And my friend said that section 16 somehow justifies a life of mine approach. We say, for the same reasons I've just said, it
Have a
doesn't.
look at 16 and remind me what it says.
16 is just the section that says that operators have got a duty in relation to the mine site, including its closure.
Okay.
We accept that, but that's not inconsistent with our construction, we say. So, there's in effect two views. They say that 42G carries with it an implication that it can only be the end of life of the sort of hoped for end of life of the mine, and we say it is sufficient if it carries out the end of authorised mining activities, and we say that nothing in section 16 or the order in paragraph 20C support an inference for it being mandatory construed with my friend's way. So that's section 41, I think. Section 40. So then moving on to section 41. Section 41 addresses the issue of the review and amendment of mining management plans. That is, of course, something which is required in this case. There was some suggestion yesterday.
You're saying that each year that they put in a new unplanned closure plan, that is ipso facto an amended mine management plan.
The unplanned closure plan, as my friend indicated yesterday, and we entirely accept, is an appendix and therefore part of the mine management plan. So when you're changing the unplanned closure plan, you are changing to a, maybe if that's all you change, you're not changing very much, but you are changing the mine management plan. So it is to that extent an amendment of the mine management plan. That leads to a need for another authorisation, and that's what we tendered, those extra authorisations. So it does lead to another authorisation. It leads to another security calculation and another authorisation to deal with whatever additional disturbance-causing mining activities are able to be carried out under the authorisation. Now, there was a suggestion yesterday that that MacArthur River could never do an MMP. I mean, if they chose to, they could never do another one, or at least, I think my friend then modified that by saying, well, at least not until 5 years before the cessation of mining, because I think condition 98 requires that. And we say that that's not right, and that condition 99 is the one that requires you to do the UCP, the unplanned closure plan, every year. That is itself a sort of a minor change to the mine management plan, but still a change. So that's not true. But in any event, it's not true that MRM can just sort of choose never to do one, because the minister under 41(1) can specify intervals, which he's done in this case, or can require a review of the mine management plan at any time. So it's always up to the minister whether there is to be a new plan or there should be a new plan. Now, if it requires amendment, it must be submitted to the minister under 41(1)(b), and then under 41(2), well, it must be submitted to the minister for approval under 41(1) and subsection 2. And section 42 provides that the operator of a mining site must notify the minister if there's going to be proposed cessation, and that we would submit is important because the Territory has a role in ensuring the rehabilitation of mining sites. I'll show that role. That's something, it's a bit of the act my friend didn't take the court to, and for that matter, a bit of the act which Justice Southwood and Territory Iron never addresses either, but I'll come to that. Then Part 4, Division 4 is entitled Security and Levy. Section 43(1) substantially restates the effect of condition 37(2)(b)(1), which is that the effect of the condition that is required by 37(2)(b)(1. That is, an operator must provide security in accordance with the conditions in the authorisation. Subsection 2 then identifies 3 matters for which a security may be required. Paragraphs B and C of 43(2), there, Your Honour will see they both start in the form of this slightly unusual expression, the payment of costs and expenses in relation to the minister taking an action. Did you see that? To do something. Now, the first kind of action is an action to prevent the minimisation or rectification of environmental harm caused by mining activities. And the second kind is the rehabilitation. Paragraph A, the purpose in paragraph A is more general perhaps, and allows for security to be taken to secure other aspects of compliance of the Act. But going back to B and C, the notion of the minister taking action gets meaning from section 83. I want to go to section 83.
Yes.
So section 83, 2 and 3 empower the minister to take certain actions that are referred to in section 43. That is, they can cause action to be taken in effect to rectify an environmental harm or to rehabilitate the mining site. So that's the power of the minister to do that. Then subsection 5 is relevant. Subject to section 44, the costs and expenses incurred by the minister in having action taken under the section is a debt payable to the territory. So
the security is just security for payment of that debt.
payment of that debt. And so when one has regard to it, one sees a scheme whereby there's an incentive created. Miners know that they're going to be liable at the end of the day, and to that extent it's in their interest to have a plan so that it's in their interest to keep environmental harm possibilities as small as possible, because they're going to be liable for it along the way, which is the harm rectification in case there's some kind of environmental accident along the way, plus also for rehabilitation. So there's a direct incentive for miners to plan to run the mine that will have the cheapest possible way of rehabilitating the mine, because they're going to be liable. And it's section 44, so if we go back from there to section 44 now.
Enables a claim to be made on the security.
Exactly. So, although it's not perhaps the clearest of sections ever drafted,
I've seen worse.
it's reasonably clear under 44.2 that if the minister's done the work required under 83, they then get to, in effect, just claim on the security.
Mm-hmm.
And if it turns out that the security is not enough, and the whole Act envisages that, and I say that because this goes to my friend's case that, the scheme of the Act is that you have to pay up front for everything, that you shouldn't start a mine in the Northern Territory. This is, as he puts it, no one should start a mine in the Northern Territory unless before digging the first hole, you can pay to the territory the amount it will cost them to rehabilitate the mine if in 40 years' time
You go broke.
you go broke. Or not even if you go broke, if you finish it, you finish the mine, but at the end of 40 years you walk away and don't fix it. We say there's nothing in the Act that says that at all. And to the extent that Justice Southwood suggested that, with respect to His Honour, that wasn't even an issue before His Honour.
No.
His Honour had a case where he was dealing with, what my client did in that case was seek to impose a security in respect to stuff that had
Past
already
costs.
been done, and that obviously has a textual problem with 43A where it has to be future conduct. Anyway, so, but I accept, and I think very properly my friend acknowledged that all of that discussion of Justice Southwood was obiter, and
Yes.
we obviously take issue with that aspect of it, not with the decision per se, but with that aspect of it. And I note that from paragraphs 5 to 7, or subsection 5 to 7 of section 44, if the security is not enough, then you can still sue for more.
Yes.
And what is unclear, and so I'm just flagging this for Your Honour, it's not something I've even raised with my client, but let's say at a particular point in time you think $200 million is enough in relation to stuff which has happened, but you did it in advance, so you asked for 200 million, things are going along, but then there's a catastrophic environmental harm issue that costs $100 million to fix. And the territory comes along and fixes that for $100 million and puts a claim on the security, and now the security left is down to $100 million. It's not entirely clear that the territory can, in respect of the past disturbance, ask for more. That's the effect. The effect of Justice Southwood's reasons, and we're not challenging this bit of it, is that you couldn't go back to get more. However, if what's left of the security is not enough, 5 to 7 say, you can still sue for the amount.
Yes.
So the point I'm trying to make is the security under the Act isn't some kind of be-all and end-all. It's meant to protect, as the Act envisages, the legal liability of the territory or the potential economic liability of the territory to fix these things, but it's not a complete panacea to it. There's a recognition that the security might end up not being enough, or the security taken for rehabilitation might be used for some other, fixing of another problem.
If you couldn't go back more, you'd be better advised to simply sue and keep your 200 million security.
Indeed, that might be wise.
I'm just, I know at the time, we would normally take the morning adjournment now, but in a matter such as this, as for yesterday, I'm happy to sit through, provided court staff do not require a break. Yes, we will take the morning adjournment now.
Doesn't matter.
Silence all stand. This honourable court now stands adjourned.